In order to establish your living trust, you will be signing a trust agreement similar to the document that we'll be looking at today. Only the first 5 to 6 pages of the trust agreement actually contain information that is specific or individualized to you, and the remainder of the document is standard legal language that we include in all trust agreements to ensure that the trust will function the way that we intend. All the information that is specific or individualized to you, the signing clerk will be going over with you at your signing appointment to ensure that that information correctly conveys your intent for disposition of your assets upon your death. I do like to point out that the first provision here, the first paragraph, is where we actually identify you as the settlor or creator of the trust, and also that you are the lifetime beneficiary of the trust. There is also in Article 1 where we identify individuals that will be named in the document, and then we get into the actual provisions of the trust. The fact that you will retain all beneficial use and enjoyment of the trust. You are able to make distributions to yourself from all of the trust property. We recognize that upon your death, additional assets may come into the trust by way of beneficiary designation. We also include a special provision that will reference a separate written memorandum that you may leave designating specific items of tangible personal property to specific people. We will provide a sample that you can use, but there's nothing particularly special about our piece of paper that we give you. Any written list signed and dated by you would be legally enforceable in order to transfer specific items of tangible personal property. Section D would contain any provisions for specific distributions that you want to be made from the trust prior to the remainder trust being distributed among your named beneficiaries. Anything that is individualized to you in this section will be addressed with the signing clerk to ensure that it correctly conveys your intent. We also include provisions that will allow your successor trustee to pay any final expenses of your estate or taxes due, such as your final income tax return, prior to making any remainder distributions from your trust. Section G identifies that your trust will terminate upon your death, and upon termination, it will explain who is to receive the remaining principal income of the trust. Anyone that will receive from your trust would be listed here. This will also contain the contingent provisions in case a beneficiary predeceases you, and may also make reference to contingent trusts that will be listed in Article 3. Article 3 is the contingent trust provisions. In here, this would be for contingent minor trust, anyone under a specific designated age that you want to receive from you. Their portion would be held in trust until they reach the designated age. It will also contain specific distribution provisions, what the trustee can use the beneficiary's portion for until they reach the designated age, and possibly who will be acting as the trustee of those contingent trusts. There may also be specific trust provisions in here related to any retirement funds that are going to go to your contingent minor beneficiaries, and it is a very long paragraph. Article 5 contains the trustee nominations. Section A names who will act as your successor trustee upon your death, as well as who would be the alternate or alternate successor trustees in the event your initial successor trustee cannot serve. It also addresses issues related to you adding additional trustees or co-trustees during your lifetime, and how successor trustees would be nominated if there's a vacancy in the office due to resignation or a successor trustee predeceasing you. It also will address instances of co-trustees and whether or not the co-trustees would have the power to act independently of one another, or whether or not they must act jointly together. Article 6 contains administrative provisions. Most importantly, this Section B, which discusses your right to reside in any residential property that is transferred to your trust. This is the provision that allows you to maintain all your homestead rights with regards to your house once it is transferred into the trust. It also has the important revocation provision here, which allows you to amend, modify, revoke, or terminate any provision of the agreement or the entire agreement at any time prior to your death. The trust only becomes irrevocable once you have passed away. Article 7 addresses the trustee provisions, first of which are all the powers and authorities that we vest in the trustee. This is a fairly exhaustive list to ensure that you have as much authority and control over your assets during your lifetime as you can, and also to make things easy on your successor trustee when it comes time to distribute assets and terminate the trust. It also contains the provision that all trustees have to account to their beneficiaries. During your lifetime, because you're the lifetime trustee and beneficiary, you don't have to account to yourself, but your successor trustees would need to account to the beneficiaries that you've named to receive your assets upon your death. It also provides definitions for how notice should be given to anyone, the fact that no trustees can be held accountable for acts of prior trustees, and the fact that all trustees can rely on legal opinions. We definitely recommend that any trustee that has a question about their duties or responsibilities obtain legal opinions. The final article of the trust are miscellaneous standard provisions, most of which are definitions of various terms as they are used in the trust agreement. However, it does contain a specific provision allowing anyone to donate or transfer property to your trust during your lifetime, as well as the spendthrift provision, which is what protects your trust estate from creditors of your beneficiaries. That is the end of the trust document. You will need to sign on the document itself, as well as a self-proving affidavit, so this will require 2 signatures.